New York City takes a loss in trying to defend its good moral character clause. Let's go ahead and talk about it. What's up, Wolverines? Welcome back to the channel. My name is John Crump. I'm an investigative journalist, and I have a book coming out on November 1st, right over there, Masters of Firepower. You can pre-order the Kindle version right now, or you can just wait until November 1st and get the hard copy or paperback. Today, we are sponsored by our friends over at Gideon Optics. Gideon Optics makes some of the best optics at an affordable price. So why spend money on an optic where you can get a cheaper optic that is just as good? Go ahead and check out Gideon Optics, and for a limited time, you can use code CRUMPY and get 10% off and free shipping on all orders. And before we get into today's story, go ahead and subscribe to the channel. It would mean the world of difference to me. Engagement is key to building up a channel, and subscribing is the best way to increase that engagement. Today, we're going to be talking about a case out of New York City, and it deals with the pistol permitting and the long gun permitting in the city. There's a guy named Joseph Sauer who sued New York City over denying his applications for firearms. Now, Joseph does have a few arrests in his past, but nothing that would disqualify him from owning firearms. His driving record isn't the best, and that should not disqualify him from buying firearms either. But New York City said because he had prior arrest and his driving record is bad and he wasn't forthcoming on his application of disqualifying things, that he lacks good moral characters and is not a law-abiding citizen, so they can deny him the right to bear arms, which is total BS because he did nothing that would disqualify him from owning firearms. Basically, New York was saying that you don't drive very good and you have some misdemeanors, so therefore you're not allowed to own firearms, even though that they cannot provide any historical analogs to say that that was okay. Before the Bruen decision, New York had a May issue system where you had to show good cause to be able to carry a firearm outside the home. Well, they replaced good cause with good moral character. And New York City tried to flip that into their rules for issuing handgun permits and long gun permits. And they try to say that it is totally constitutional because the Second Amendment only applies to law-abiding citizens with good moral character. The judge disagrees. Let's go ahead and read part of his decision. The court disagrees. The conduct at issue is the possession of a firearm. The question is whether such conduct in possessing firearms may be constitutionally regulated. Whether an applicant lacks good moral character is not part of the conduct being regulated. The requirement that an applicant submit to a determination of moral character instead is the regulation itself. In arguing otherwise, the defendant impermissibly merges a person's conduct with their status as defined by the regulation. Bruen, however, draws a clear distinction between an individual's conduct and the regulation which burdens that conduct. Basically, he is saying that New York City is full of crap and the stuff that they are trying to pull is not constitutionally protected because the Constitution mentions none of what New York is trying to say it mentions. And I tend to agree with the judge here. The judge also said that the challenge provision is very, very close to the provision that got knocked down in New York's May issue law. He stated the challenge firearms licensing provisions land very close to the problematic May issue laws criticized in Bruen, which is very, very true. The challenged firearms provisions empower a city licensing official to decide not to issue a permit or a license for a firearm based on that official's discretionary assessment of the applicant's good moral character and the determination of a vaguely defined presence of good cause. Much like the proper clause inquiry invalidated in Bruen, permitting denial of a firearm license based on a government official's good moral character or good cause assessment has the effect of preventing law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. So the judge basically smacked the shit out of New York City, claimed that their law is unconstitutional, and invalidated it. Basically, he issued a summary judgment for the plaintiff and issued injunctive relief. Injunctive relief against the good moral character clause does not go into effect right away. The judge stayed his own decision until October 26th. This is to give New York City time to appeal to the circuit court, which I am sure that they will. What they're going to do is they are going to appeal to the circuit court and ask the circuit court to stay the decision until it can be heard. And if we know of anything from the past, this is very, very likely to happen. The circuit court will have to take up the good moral character clause eventually, and I have a feeling that it will be struck down and they're just trying to stall it. Much like in the anti-yacht case, they are trying to stall it because they know that their hands are tied because of Bruen and they have to make a decision. What they are hoping is, and a case goes up in front of the justices of the Supreme Court and they rewrite Bruen somehow and give the circuit court a way to fine for the defendants. I don't think that is very likely, but hey, who knows? I can never tell what the courts are going to do. Or a case goes up in front of the Supreme Court and they rule that good moral character clauses are unconstitutional, and therefore the circuit court does not have to rule against the defendants because they can just say, hey, the Supreme Court says this is what it is. In the end, I think they're going to have to take up this case. They're going to have to take up the Antioch case, which is another case they've been dragging their feet on. They have to kill the CCIA in New York, and they have to kill good moral character. But they do not want to do that. But their hands are being forced, and that's why they are slow rolling all these cases. In the end, I think the New York gun laws are on their way out. They are kicking and screaming, but they are dying out, and we will see some type of action here in the next couple of years. Now, a couple of years sounds like a long time, and believe me, it is, but I do not see it being any quicker than that. So I would expect the circuit court issue a stay on this judge's decision, and yeah. All right, guys, if you like what I do here, give me a big thumbs up. It really helps out the channel with engagement. I have tons of ways to support the channel down below. Check out my new book, which wherever it is, right over there. And with that, we are out of here. So stay ever vigilant, stay ever free. The decision is linked down below in the description. So if you want to read it yourself, you can go ahead and read it yourself. All right, guys, love you very much. Wolverine's mother.